Okay, welcome back. So lots of you saw the previous videos talking about the letter of threats against me and against another YouTuber who I'm not going to name in this video, and I'm not going to name the company or the directors or even the law firm involved that sent this letter. But what we are going to do is talk about the letter, because I think this is important, because a lot of people receive threatening letters and they are threatened by them. I mean, they are sent either making legitimate threats or threats that might not be so legitimate and not have a basis in law. So what I thought we'd do is go through this letter, obviously sans any details and names and anything else, and see what we think of it. So to that end, I've brought our special learned friend, Mr. Alan Robert Shaw from Art, Media and Law. And yes, that rhymes, doesn't it, Al? How are you doing today?
It does. Yeah, I'm very well, thank you. I'm recovering from a weekend in York, training up a bunch of new barristers, which was a wonderful experience because just their enthusiasm it's really infectious. And also, we were all talking, all the trainers behind the scenes, that it really ups your own game, this, because the way that we work, and I did a video on what we call the Hampel method. We are supposed to demonstrate excellency in advocacy, and the trouble is you try to do that, and then you just mess it up yourself. So then you have to say, yes, well, this just goes to show how difficult this is. But yeah, that was a wonderful weekend, and I'm away next weekend to doing some more barristers. So yeah, it is the season to be teaching.
Indeed. No, they're always fun, those sessions, but probably one of the most fun part of all the training is doing the live sessions and seeing how you can improve, and everyone can improve, including the trainers. But so, yeah, no, fantastic. So let's take a look at this letter, because this letter was sent to me. And as I alluded, I didn't really allude, I spelt out in my previous video that there was not any substantial threat as such against me. It was just complaining of the previous video. Now, obviously, these things being in the public domain have their way of getting out of control. But when they resorted letters threatening people, I felt it's important to talk about it, because it might be guidance for other people. So this is not to be taken as legal advice. It's not to be taken to be inviting any other lawyer or anybody, in fact, to respond to it. We're not calling out them to disagree with us publicly. This is just our public breakdown of a letter of threat of some sort so that people can better understand it. And no doubt there'll be questions and stuff that follow. But so let's have a look at it. So alleged threat of infringement proceedings. Now, that wasn't against me. That was against this other YouTuber, as you probably recall. It was a threat that he was originally, at least, infringing on the trademark, which obviously was not the case. And that was what my original video was to rebut. Because there was not any real trademark infringement going on there, because he wasn't marketing goods or services. So comments on that bit, first of all, Al. I presume you saw my other video and you know what we're talking about.
I saw your other video, and I'm always cautious to say I know what you're talking about, because I never understand anything like that. But yes, I certainly understood what was going on. I mean, yeah, what's interesting about these letters is, I mean, people send legal letters all the time. Some legal letters have very specific statuses and rules that apply to them. I mean, a letter before claim or letter before action, which is the letter that you send before you actually sue somebody, they're governed by what we call pre-action protocols. And there are pre-action protocols for all different types of litigation. For instance, there's a defamation pre-action protocol and a construction pre-action protocol. But there's also a general one that applies, to all, it's a catch-all for all letters. And sets out certain rules as to the format of the letter, the information that it contains, and a timetable for responding. But this is essentially, it's what we call a cease and desist letter. Now, interestingly, cease and desist are words that have identical meanings, but they come from an era in the law where it was very common to use two identical words together just to make a point. I quite like it. Any linguists out there, apparently there's a proper term for doing that. But it's like, it's like hue and cry. It's the same thing, but it's just almost like quite poetic. But this is effectively a cease and desist. It identifies one of the videos and asks for the removal. But the question is, are there any grounds to do so? Now, it seems, reading through this, they've abandoned the trademark issue. It's like, oh, the video contains one of our trademarks and therefore it's an infringement. Generally speaking, that wouldn't apply. Even if you are criticising somebody and you are doing it for commercial gain. And to give you one very topical example, if ITV do a drama about the shenanigans in the post office and they use the post office logo, it's the same if whether it's an actual news story where you use the brand image of the company being talked about, or it's a dramatisation where you may set the drama and use the logos of organisations and the trademarks of organisations just as general scenery. Like, if you film a scene in a post office, then you're going to make it look like a real post office with the post office logo. Even if ITV do something like that, and obviously they are by definition a commercial channel, they are using another organisation's trademarked and possibly copyrighted materials, and they are profiting from that. But that isn't an infringement because it's part of the authenticity. It's almost like eidetic in that it's necessary to include that material just to be able to convey the story. So the fact that somebody catches, your logo or your trademark or your, even it's not private information if you plaster information on the side of a van, even if somebody's benefiting commercially, especially if it's a sideline, like this is somebody, there's a lot of these videos where cyclists post up examples of what they consider to be sort of, bad behaviour on the roads, and they monetize those channels. Now, GDPR can come into play, but generally speaking, it's this realistic, do you have a realistic expectation, a reasonable expectation of privacy? And when you're driving about on the roads, you do not. Also, we have this idea of what we call there is no confidence in iniquity. And that says that even in a situation where you would normally have an element and an expectation of privacy, a classic example is non-disclosure agreements. It is a defence to breach that privacy, to show that you are highlighting wrongdoing, or you are correcting a false impression. This happens a lot in an employment context. Somebody will do a non-disclosure agreement so they can't talk about something. But then if somebody goes out there and gives a false narrative, and another person comes in and says, well, actually, that's not what happened. This is what happened. You are misleading, you are misleading people. You are misleading the public. That can be a defence to breaching even a contractual non-disclosure agreement. So the problem for this company here is, this has been a thing that's gone on for years. When you had all your Roger Cook style watchdog programs and things like that, people can threaten defamation proceedings, but they can't really bring any proceedings under sort of intellectual property laws because it's just that's necessary to tell the story. The second complaint is that some of the comments on the videos are disparaging. But a problem for a company there is who is responsible for that? Comments are posted, on YouTube, which counts in law as a website. So they can theoretically go after the website operator, being, YouTube, Google, Alphabet, whatever they're called. But then they have what they call a Section 5 defence, because that's Section 5 of the Defamation Act 2013, which essentially says, they're not, the website operator isn't responsible for things that are posted there, and especially if they don't know who people are. Now, can somebody who is aggrieved ask for something to be taken down? Well, yes, they can, because there was a case years ago called Godfrey and Demon. Demon being one of the first sort of internet providers to the public. I used to have a Demon account, and what was established in that case was, while generally somebody who has something on a website isn't responsible for it, if the aggrieved person highlights it, brings it to somebody's notice, says this is what I say is wrong with it, and then it isn't taken down and it turns out to be, say, defamatory, then there may be action against the party that didn't take it down. But again, that is the website. In that particular case, they had to go after Demon because they were they were the internet service provider, so they were the correct target, not necessarily the people who actually operated any particular website. So yeah, I can understand why they are aggrieved. I mean, like I say, we don't talk about defamation anymore. We talk about all media lawyers now. We say that we do a reputation management, and the interesting thing about why we've changed to that is because defamation proceedings are just one potential sort of arrow in your quiver. But a lot of the time when you do reputation management, a lot of the advice I give is just leave it. There's a saying in defamation, today's headlines are tomorrow's fish and chip wrappings. And quite often the best advice is keep your head down, wait till it blows over. And I think, I'm not giving them advice here or anybody advice, but stoking the fire and doing things like this just keeps the story going.
And that's exactly what's happened, isn't it?
It is. And one thing that's interesting is they haven't said you cannot comment on this letter, because there had been a series of very well-known legal firms doing that on behalf of some very powerful people. They had been writing saying, we are threatening you with defamation, and also you are not allowed to publish this letter or refer to it. Now, the SRA have come down really strongly on that, and they've said it is a very, very serious breach of their regulations to imply that, because unless it's something that does contain confidential information, say it was a letter in family proceedings where children are anonymised, or there was an injunction in place prohibiting the release of certain information, threatening letters before action. You can do what you want with them. You can go out there and wave them around and say, I am being sued.
There's no quality of confidence in that at all, because I have no relationship with this company, the client company. I have no relationship with the lawyers, any of them. I've done my video based on what I think for the general public guidance. I have no connection to them at all. So there's no quality of confidence at all in this letter to bring this up and talk about it.
Well, absolutely. So you can comment on this. I mean, also when you're involved in litigation or potential litigation, the defamation law allows you a lot more flexibility to comment on things, because it's like I was mentioning in the Lawrence Fox case, where he was trying to use that tit for tat thing, where part of his argument was, I was merely commenting about things that had been said about me. And the law does actually give you some extra protection there. If somebody says something bad about you, you can deny that in very robust terms. And that cannot found a defamation claim in itself. So if somebody says, I accuse you of the following, and you say that is completely untrue, you are lying, you are making all this up, you are not to be trusted. Now, normally it's saying about somebody, you're a liar and you make things up and you can't be trusted. That is potentially defamatory. But when it comes to responding to things, then you actually are given a certain amount of leeway, and people can't sue you on the back of that. I mean, that was interesting because this cropped up in one of the Trump cases, and we're still trying to figure out why they didn't run that defence, because they have the same rule in the US, and it just seems for some reasons, whether it's tactical or the lawyers just forgot, they never actually ran that defence. But yeah, that's something you can do here. So it's all it's this Streisand effect. I mean, like I say, the best advice anybody can ever get, where something like this, is happening. And yes, okay, I can understand people put fake reviews up and things like that. Although usually they're within review websites, there are facilities for sort of saying to them, I am, in the middle of a controversial story and these are fake reviews. That's the best way to do it. I mean, in terms of reputation management, not advising anybody, but had this firm just gone, oh yeah, sorry about that, that was really bad. We've had a word with our driver, he apologises, he's learnt his lesson. Even if an excuse, you got to be careful saying, oh, it'd been a long day or something like that, because you're setting yourself up for DVLA getting involved or, road traffic offence. But, if they'd have just said, yeah, that was completely out of order, sorry about that, we love cyclists really, and we've had a word with all our drivers and just reminded them of, the highway code, then people have sort of said, "Oh, what a great company!" Yeah, because you see this where people just take it on the chin.
That's what they should have done, really, because all they did is to, as you say, stoke the fires, and then I responded to that one video with this one here that they complain of. Although, as we've said, we'll come to that there is no real complaint here, apart from the comments that were left, as you've just outlined. And it's the commenter, ultimately, that they would have to take that up with, or potentially YouTube, and they might remove the comment, but that would be the end of it. So they complain about this one here, which is, my video, unjustified threats can cost you, which it can. You make an unjustified threat of trademark infringement, it gives rise to several remedies, including damages and an injunction and so on. So I've obviously blanked out this big bar here is the name of the firm and everything else, which are blanked out. This bit here is blanked out because it's something that was said between the other parties and nothing to do with me, so it's not right for me to display here. Obviously all the names are redacted, but now this says, this was clear anyway, that they say the client accepts that the original threat of infringement was misconceived, misstated the law, shouldn't have been made. But then, and the reason I've left that in is because that supports a rebuttal from me against this letter, which then goes on to say, the corollary of this vlog post, my video, is the vilification of the client, and with these comments, which I've also redacted for the dignity of their clients and the solicitor for that matter. But the point of this is, it is very firmly targeting me, and several times references this phrase, and it's a go-to phrase when someone wants to criticise a barrister with a public profile, such as it is. They say, as a barrister, and then this is the bit that I've highlighted, which I really take issue with, because I do my videos to help people understand the law, and I hope that it does so. But then it says here, as a barrister, it is giving racist, fascist, antisocial antagonists an implied sense of legal cover. But that is obviously not what my videos are for. That is an unfounded allegation against me. But then the bit that's underlined at the end of that paragraph, this evidence suggests a clear case of harassment. And the question marks are mine, because by whom and against whom? Because clearly it must be referring to the comments by who they allege to be racist, fascist, and so on, and presumably against the company in question underneath the video that I posted. But again, all of which nothing to do with me. But to link that to some implication that there's a sense of legal cover for them, I think is ridiculous. And as I say, I've blanked them out for the dignity of the parties involved. And we'll come to this bit about the infringement proceedings in a minute. But before we go on to that bit, thoughts about that bit, Al?
Yeah, this is the problem with this is you have to look at what we call causation. And whose problem is it? Whose responsibility is it that people are putting nasty comments? Well, first of all, it's not harassment, because it's it has to be a course of conduct, and you'd have to show that somebody was doing just more than one particular post, or more just more than one comment. But people, when their wrongdoing is exposed, they do quite often they are subject to sort of disdain in the public. And this crops up at a very serious level, because, for instance, if people are convicted of horrendous crimes, then obviously, after they've been released, they can have a target on their back. And there's this issue about what can you do about that when you get people applying for anonymity, especially when people were, underage when they commit offences. But the law is quite clear. There is a strong public interest in being allowed to identify wrongdoers. And I can only think of 5 cases off the top of my head where they've allowed anonymity for convicted criminals, say, because they were convicted of very horrendous crimes. They were called Mary Bell orders after a particular offender. And that's where they will give people new identities just because they accept that, yes, there is a genuine risk to this person. But it's such a high threshold, and it's only been used in cases with, like, Maxine Carr and Thompson and Venables, people like that. The courts accept that if you are mixed up in wrongdoing, then it's in the public interest that people can talk about you and comment on you. And you see, that's another defence, certainly to any sort of defamation aspects, that this is a legitimate topic of public interest, and it is in the public interest to discuss it this way. Now, obviously, there isn't a public interest defence so much to harassment. There is, however, you are just highlighting crime. That's one defence to harassment is, yes, it may well be that this person does suffer something that could be called harassment in an objective sense. However, it doesn't amount to harassment because there is a justification for doing the action that led to that, and that is merely commenting. I mean, if people were to go out and go, yes, string these people up, it's terrible, and actually give, a call to action, then we've got all these 2007 Serious Crime Act things, which is, what we used to call incitement. We don't call that now, but, inciting people to do that. That has to be very deliberate. You have to have the requisite mens rea, as we say, the intention to incite people to do that. And the mere fact that legitimately commenting on a story may result in somebody in that story receiving negative attention from third parties, the law, allows a lot of leeway there, because otherwise you wouldn't even need defamation or confidence proceedings. You could say, I am bringing a claim based on the fact that people now are disparaging me, or I am losing work. And it's like, well, that's a matter for defamation. No, the cause of action is based entirely on the outcome, not on how we got to that outcome. So it's a very difficult ground to argue. I mean, but the thing is, it's always worth sending cease and desist letters, because a lot of people, they are discouraged by them. They do put them off, and nobody wants the threat of legal proceedings hanging over them, and especially when they come on official letter-headed news paper. And I'm not suggesting that any lawyers involved here have done anything wrong. It's perfectly legitimate to raise these issues, and I don't think they've crossed any lines in terms of what they're doing. I just think it's not a very strong argument that they are making. But we send letters. We send letters. We send legal letters all the time that don't have particularly strong arguments in there. But there is an argument, and you have to. Your clients are entitled to raise it. But I just think, like I say, I'm not advising anybody here, but had somebody in a similar situation come to me, I would have said, bang a nice apology out there, because there's this rather weird phenomenon that, generally speaking, people are happier with organisations where something went wrong and it was put right than if everything was right in the first place. So if you go out and have like a perfect meal in a restaurant, you might be quite happy with that. If you go out and there's something wrong with the meal, and then they come out and they apologise and they sort it, and even though you've had the hassle of them recooking it or something like that, people have more positive views then on the fact that somebody actually corrected something. So in terms of reputation management, terribly sorry about that. Thanks for bringing it to our attention. We've had a word with our drivers. They're all good lads, really, but, because everybody would go, yeah, we've all made mistakes driving.
Absolutely, and that's the real issue here, is they've gone on the attack rather than, as you say, taking a positive action to remedy what's happened. And as you say, the complaints of I I don't think they amount to harassment because it wouldn't be a course of conduct. I expect people have just left a comment. And even if it's a number of comments, does it cross the threshold for harassment? Probably not. It's probably just a heated comment left by a disgruntled viewer and whatever. So they're quite right to make those complaints. But as I've said in my previous video, nothing to do with me. It's aimed at them, not me. But also this bit here. As the threat of infringement proceedings has been withdrawn, the remedies referred to are no longer available, leaving, they say, only the damages. Well, that's not correct either, because it's a bit like committing a crime and then saying, well, it's a bit like stealing something and all of the elements of theft are there, but then when you're caught trying to give it back, not saying that they've been accused of theft, they haven't, just to be clear. But if someone were and then said, well, actually, let's just give it back, that doesn't negate the crime and it doesn't remove the offence. Just like littering, a lot of people talk about going back to pick it up afterwards. It doesn't remove the littering offence. There could be a bit of common sense in that they've righted the situation, but people think it negates the offence. It doesn't. Just like here, the threats of infringement have been made, not against me, against someone else, and just to withdraw those doesn't remove the remedies, because the person might feel that they want to have an injunction to prevent them from coming back again, because they might continue to feel threatened, that it's not been put to bed yet. And the reason that law was drafted in was so that companies can't weaponize their trademarks and go around and bully companies when there isn't, in fact, any infringement there. And so that they don't have the hanging threat moving into the future, so that they've got a finality, because law and the legal process is all about finality. They want that there needs to be a finality to proceedings, to claims, to complaints, and so on. So, as you say, Al, we're quite right to make a complaint as such. I just feel they've addressed it to the wrong people.
Yeah, because first of all, it's who are they going? Because they're trying to hold you responsible for the actions of other people. But also the mere fact that if somebody comments on something and the underlying story, changes. Let's say, for instance, they had come out and apologised. That wouldn't necessarily mean that, they wouldn't have any recourse to take down the original video. It's like, if the post office hand out all the compensation and give all the postmasters millions of pounds so that they're all better, they can't suddenly go around to ITV and say, please can you take down that drama now? It's not necessary. You have to be careful that you keep people up to date. It's okay to leave an original article or an original video up. Now, when people do websites like newspapers, they will, if the situation changes, sometimes put a little comment, like a little appendix at the bottom saying, "Oh, since this article was published, here's a little update," and that often, that's a good way of saving you from defamation proceedings. But in this particular case, you're keeping people updated. There's a further video. It's all fair and accurate commentary on what's going on. The only danger would be if somebody was to repeat a video saying, "Oh, they are still threatening these actions." Well, they're not now. They've accepted that it was a baseless threat in the first place. It's a baseless legal threat, and you think people might learn their lessons from that rather than have another go. But that doesn't negate the fact that the first video was completely legit in terms of commenting on this. And that's the problem. There is this permanence on the internet. In the old days, if it was just like an article in a newspaper that would have been thrown away, it's less of a problem. I'm going to feel really bad there because I've just cut a certain person off again. Just getting me a bit of a habit here. But yes, there wasn't this element of permanence unless you went to a newspaper archive in the basement and rooted around. Then you wouldn't be able to find the story again. But now the problem for them is if you Google, then it's going to be there on a server somewhere. And that's why you have to be really careful about reputation management. I mean, I feel sorry for teenagers and young people today, because I'm very, very... We actually had this discussion when we were at the weekend, and we were just basically sat around the table going, if there had been social media in our day, none of us would be barristers. And certain people wouldn't be judges either.
Well, reputation is everything, isn't it? And I for that very point, I think that transparency is everything as well. And it's things like this. I also think that a lot of stuff now that, for those that are obviously not in the profession, there's a lot of emphasis in recent years against bullying, against poor conduct, which happens in every profession. And we obviously try to minimize it. And recently, there's a lot of moves to publicize it, to condemn it, remove it, and so on. And so this is in that spirit. And I think this final bit of this letter is one such thing. Because this is not to say many lawyers do it, and this is my interpretation on the wording here, and I'll explain why that is. Everyone else is entitled to their own views on it. But this final bit was directed against me, and whilst phrased as a question, as some people have noted, is the point 4 here. While some people have noted is it just a question, the writer knew exactly what they were doing in writing that by saying, by writing the question, have you inquired with the Bar Council whether you've acted within the Barrister Professional Rules of Conduct? Now, the rules of conduct are set by the Bar Standards Board, not the Bar Council, so it's sort of outdated anyway. But the writer knew exactly what they were doing to then follow it with that line afterwards, you requested to take this down. So it's an implied threat of reporting for misconduct followed by a demand to take it down. Now, I repeat what I said in my previous video. In my view, that's out of order. And that's the sort of behaviour that we shouldn't accept as a profession, particularly cross-profession, solicitor to barrister or barrister to solicitor. If I were going to make a report or whatever and state it as fact, that's one thing. But putting it in a letter before a demand made of somebody else, I think is out of order. And so this is the sort of thing we really need to stamp out. And I'm sure you've come across that in your career, Al, without naming anybody or anything in particular. But when you agree, this is, to strive for, look at what's happening with the police in recent years. And, I support the police because they've got a hard job as it is with funding cuts and everything else. And it's a hard job before they start. But there's a big move towards removing what is seen to be misconduct within the police. And they're making good progress with that.
Well, I've never seen, actually, in a letter from a fellow profession, ever a threat about regulation. Now, maybe I'm not suggesting that's because I always send perfect things, or there's nothing to criticise. But it's just never featured, and it's something even when I've, because sometimes you get involved in very bad-natured, bad-tempered litigation, and the courts try to clamp down on that. But, the law reports are full of examples of people where they've said, you are really crossing the line here. And there's a judge saying, in the old days, it's bad enough that, the parties had to hate each other, but apparently now so do the lawyers. But even in those absolutely horrendous sort of, bad-tempered exchanges, nobody threatens with, to report to the regulator. It's usually, we will make an application to strike this out, we will go for costs on an indemnity basis, and we will highlight everything to do with your conduct of this litigation. But it's all within we will use, the cost rules in litigation to penalise you, and it's going to cost you a fortune, and, all that sort of thing. But there is this idea that, you don't report people, you don't threaten people. Reporting people to the regulator, it's something we are encouraged to do if we see egregious behaviour, to use their word. And actually, we have to do. And again, this is something we're talking about on the ethics course. But that is things like if we see bullying, if we see abuse, if we see misconduct in terms of misleading the court and things like that, then yes, we are actually under a duty to report. But little sort of, I have to say that little, and I'm going to say, in my opinion, snidey comment, have you told so-and-so? It's almost like, have you told the wife yet about such and such? If they'd have just sort of said, we think this crosses the threshold, and we would we would remind you of CD 5 within the handbook, and we would suggest this is either a breach of that or crossing the line, that might have been fine. But have you told the
Just
regulator yet what you've been doing? Yeah, it's just like, oof, no. So yeah, that was, and the trouble, spoiled the letter. I mean, we can criticise the contents of the letter, but in my opinion, that was a very unprofessional thing to do.
It was. It just draws the whole letter to a sour conclusion. I mean, had the letter been a different tone entirely and said, this is all what's happened and our client's very upset about it. Now, I do feel badly for the clients involved in this, because ultimately the driver, who obviously has not been named, and it's nothing to do with I even said in my original video, or subsequent video, whichever, that one driver driving badly should not harm the reputation of a company. People should not leave negative reviews about it. They certainly shouldn't leave horrendous comments about the company or the owner or anything else because of one driver. If there were a courier, I'm not naming any couriers, I've always had good experiences with couriers that I've used, for the most part anyway. And so if one courier was known that every driver was terrible and they're always breaking the law and all this sort of stuff, the company then might get a bad reputation. But in this case, one driver driving badly shouldn't really do anything for the company's reputation. So if the letter was to set out, our clients are upset by this, they accept that it was wrong, which, to be fair, they sort of do, but they're doing it at the same time as making yet further threats, which is, again, wrong. Now, I'm also going to say here that I won't prompt you for your thoughts. You can tell me what you think, Al. I haven't mentioned this beforehand. This is a free-flowing conversation. But I'm also going to say here that regardless of whether or not, and obviously I don't know, but regardless of whether or not that final paragraph here was anything at all to do with the clients involved in this, regardless of that, the lawyer put their name to it and sent it. Because I certainly know from my point of view, if a client of mine said, threaten them with this, my response would be, well, first of all, why would you say threaten them with that, as in regulatory misconduct? I would say, why threaten that? Do you think there is? Let's talk about it. And if there really was, if they thought they really were misleading the court or withholding evidence, or they'd made verbal or abusive threats or any kind of other kind of misconduct thing, we'd talk about it. And as you said, Al, I would then say, well, maybe we'll set it out properly and say, we believe you to be in breach of XYZ rule because of these reasons. But not in that way. I would never have written it in that way. Thoughts?
No, I entirely agree. And to be perfectly frank, had somebody said, I want you to throw something in there threatening somebody to their regulator, I would say, well, actually, no, because that's a completely unfounded threat, and that is crossing a line. I mean, you know, this is the thing. You can't just write what your client wants on your headed notepaper. And judges are very, there's a great quote from a judge where he says, lawyers need to stand up to their clients and tell them what is and isn't possible. And the courts have reminded, this is in the context of, letters in litigation. They said, remember, yes, you follow your client's instructions, but you have absolute conduct of how the case is run, and it is for the lawyers to decide what tone the letters should take and what should be in the letters. And, if clients want that to go further, you can say, well, tell you what, de-instruct me. You personally can write what you want to the other side, but I am not writing this and putting, just because you want this to go with my letterhead on it. I mean, funny enough, there was people have been commenting in sort of legal circles. There's an advert in the US where they wanted somebody, they were going to pay them $20 to $40 per letter. And what they said is, must be somebody, freelance attorney with own law firm to send out letters. And we're going, this is literally just somebody saying, we will pay you $20 to $40 per time for you to send out abusive letters, so it's you that actually gets disbarred and loses your law license. I mean, we can't see there's going to be many takers for that. But no reasonable lawyer is going to write just what the client wants. The clients obviously can have input on letters. Oh, can you do this? Can you do that? But this is something we, especially as barristers, we have to explain all the time and say, what do you want out of this? What do you want out of this? Your end goal is to succeed, whether that's to defend a claim or bring a successful claim, and that will not be achieved a lot of the time just by sending off aggravating, pointless letters that, apart from anything else, if we go to court, a judge is going to be reading these out and criticising us, and quite rightly so criticising us. And the other thing I noticed, the last sentence about accepting service. Generally speaking, with service, there are certain rules, which is it's got to be posted or personal service. You can actually apply to the court for permission to do it another way, and you can agree it with the other parties. And I quite often do this, where I'll say, oh, by the way, look, for convenience, are you happy if we deal with everything by email? That's fine. But putting that in and then demanding what is essentially a favour, it's like, please confirm that you will accept service and you will accept it by email. It's like, well, no, because you are asking for a favour there, because the rules are quite clear on what counts as service. So if you do want to, if you do want me to make life convenient for you, maybe be a bit nicer about the way you ask. But there you go.
And it goes without saying, I think, if there were a positive twist to this, I'd be just as happy to put that out as well. And I'm sure that however many people end up watching this video, I know a good few 100,000 people watched the previous ones, would be very happy to hear a positive outcome. So again, not as advice, but it's what I would say to clients and say, how would you like this to end? You know, what is the end goal? As you just said, what are you trying to achieve? I start most of my conferences with what are you trying to achieve? Because if you get halfway through a conference and then find out that their goal is so lofty that it's just unworkable, it's just not going to work, then there was no point having the first half of the conference without knowing that, because you're not going to achieve it, and there'll be disappointments, and then you have the difficult conversation later on. Whereas I'd prefer to have the difficult bits at the beginning and say, what is your... I've had these conversations where someone had something very, very expensive and their goal is to return it and get every penny back. And I say, well, that's not realistic. What we might achieve is X, Y, or Z, but your plan is not realistic. So you set the expectations at the outset and then work forward from there. And so I think that should have happened here, really. What was the desired outcome? The desired outcome of this letter, from my perspective, was that I take down the video. I think they went the wrong way around it. I think if they'd have said, if they'd have accepted they did accept that the original threats were wrong, but if they said that they're sorry for the way it's been handled so far, etc., could you please take it down, rather than make threats of this nature, we may have done so. You can't, you just can't ask for a favour once you've made a threat. It's doesn't give.
No,
anyway, I hope you found that interesting. Any final thoughts?
No, just to say, it's because, like I say, had they have handled this differently, stuck out the apology, and even if they'd have written to people saying, look, we appreciate this, the situation was updated, we've put out an apology, would you mind updating all your viewers about this? They could have spun this, because the irony is, actually, you had a look at their website, and the irony is they clearly are really good at their proper job. There's some really nice stuff on there. They could have really spun this and turned it into a positive. And like I say, that's what we now do in media law, reputation management. And, in some ways, you say there's no such thing as bad publicity. There clearly is. But also, they're a trending, while they were trending, they could have put such a different spin on this, where people had gone, actually, they're fairly decent. Because let's face it, half the viewers probably hate cyclists anyway, and might have been on their side. But had they just gone, we were completely out of order, sorry about this, we've retrained our drivers, we've had words, we do apologise to all concerned, that would have been the story. And I've had so many people going, oh, that's really decent. That's so rare to see people doing that these days, owning up to stuff. They might have actually ended up, in a better position than they were when this story started. So there's the irony.
Yeah, absolutely. And I will end by agreeing with you completely, because I've looked at what they do. I know that industry very well, as it happens, and I think they're obviously good at what they do. It's a difficult thing to do. They're obviously good at it. Maybe they do want to come back and right a wrong and repair and rebuild, but we'll see. But appreciate your thoughts as always, Al. I'm sure everyone's enjoyed listening to them as well. Make sure you do pop over to Art of Law. Linked in the description always. Al's channel's blowing up. Excited, ecstatic. Make sure you go and do that. But thank you all for watching, and we will see you next time.